Now, let's get into our lesson today. I don't know that we'll get through all of it, but we'll do the best we can. You know, one thing that's true in my life, I love taking tests. The harder, the better. And so here are some of my current certifications: Illinois and Missouri Bar, CPA, regular member of National Association of Parliamentarians and the registered parliamentarian, professional registered parliamentarian, technician class, Federal Communications Commission, general class. These are amateur radio licenses, and the amateur extra class, which is that is an extremely difficult test. Diesel mechanic, Marine. I'm a certified diesel mechanic, and AED user. Now, but I've got a new one, number 12, since last year. Private investigator. Yes, that's right. So I've had to, I studied and I took the test in May. There was only 2 people in the state of Missouri taking it. It's very difficult, about a 6% pass rate. And I was able to pass it. And now it's a new skill that I have, and I want to show you some pictures of you know, as a private investigator, you have to be stealthy. You don't want people to see what you're up to. So I've got some costumes. You may recognize me. Now, when I'm in an area where I'm well known, I have to have a deeper costume. So there you go. And as you know, my people ask me, "What did you do? What did you get that for?" And you know, I don't know the answer to that. I just was looking forward to another challenge. And now I'm already thinking ahead to what am I going to do next year. So I haven't decided. As you know, I'm an astronomer. My big imaging telescope there on the right, here it is. You can kind of see the complexity of it. It took me about 2 hours to set that telescope up. I had to wheel it out into the driveway on industrial wheels and go through about a 50-star alignment to make sure it was pointing in the right spot. And then you're dependent on weather in Springfield, Missouri, light pollution. So I was able to take some pretty decent pictures, but not as good as if I could get that in a truly dark location. So we moved the telescope about 2 years ago now to a mountain in New Mexico. And here's the observatory where that telescope now is situated. We share this space with about 10 other astronomers. And there's the interior. And it turns out that the nearest town is Roswell, New Mexico. So I thought you'd find that interesting. I love this quote from the astronomer Johannes Kepler. He said, "The treasures hidden in the heavens are so rich that the human mind shall never be lacking in fresh nourishment." Isn't that great? Here's some of the pictures I've taken from that mountaintop, 8,000 feet elevation, away from city lights, pristine conditions. Here's some of the pictures I've taken. That was a 12-hour image over about 5 nights. Here's the Omega Centauri globular star cluster. Here's a large spiral galaxy near the Big Dipper. And here's an emission nebula, a couple of nebula. And then my most recent image, which is 24 hours long, of the Rosette Nebula using the Hubble palette of filters. Now, a year ago, we had the total lunar eclipse, solar eclipse. And I had to rig up a filter for my 90 millimeter refractor, and we drove about 150 miles, so we were in the path of totality. Boy, the weather was iffy where we were. In fact, the clouds started rolling in a couple hours before the eclipse, and I was ready to go home. But we'd driven so far, we decided to stay, and the clouds parted enough that it was kind of hazy, but I was able to get some pretty good shots. Here's the moon encroaching on the disk of the sun, and then this at the totality. wife and me. I can't keep calm. What does that say? This is my first total solar eclipse. We're eclipse chasers now. And then I took this picture, this set of pictures of asteroid Florence. You know, I got an app that's called Asteroid Alert that alerts me to asteroids zooming overhead every night. It averages, I maybe shouldn't tell you this, but there's about 2 a night on average. And some of these are quite close, like Florence. That was closer than the moon. And in astronomical terms, that's nothing. It was the size of 30 Egyptian pyramids. Now, if that would have slammed in, there would have been regional devastation on planet Earth. So, unfortunately, at this point, there's nothing much we can do about it because we don't even discover many of these till they've passed overhead. But I'm out there doing my part to try to track some down. So here's an image that I took of Florence. Anyway, you can go to seetheglory.com, my website, and see these. We also have audio and video tapes. Now, I want to move into our session today. I added something late last night that occurred to me, an article I wrote for my Church Law and Tax Report newsletter that's called Rethinking Church Membership. And I know there's a lot of debate on what is the ideal form of church structure, church organization. Do we want members or not members? And the kind of the frustrating thing is the New Testament. I went to Harvard Law School. I took some courses at Harvard Divinity School, and one of them focused on New Testament church order. What was the nature? It's kind of an interesting question, isn't it? If we could go back in time to about 50 AD and walk into a Christian meeting, what would it have been like? What was the form of worship in the early church? The New Testament is largely silent on that question. So that's resulted in a lot of diversity in church models. But in recent years, we've seen kind of a move away from membership. And it's interesting when you look at the history of church membership. It was a kind of a foreign concept in the early church. There was no such thing as membership. You became part of the body of Christ through baptism and confession of a creed. Became the Nicene Creed. Ultimately, there was an Apostles' Creed before that. And so things stayed like that, where membership was not given a lot of prominence in the church. Everybody just assumed if you are baptized, and you state the creed of the church, you're a Christian. You're part of the body of Christ. But the idea, in a legal sense, of membership was foreign. That changed in the 19th century, when there was an explosion in this country of voluntary organizations, most of them charitable, in communities. And people started gathering together in these charitable organizations. And eventually, nonprofit corporation laws were enacted in almost every state. And these organizations recast themselves as corporations. Churches joined in that process. And so starting in the mid-19th century, we see this occurring. And here's a quotation from Alex de Tocqueville, who was a French political scientist and visited the United States in the 1830s a couple of times. And he said this is right at the time that these nonprofit corporation laws were coming into being. Americans of all ages, all conditions, all dispositions, constantly form associations. They have not only commercial and manufacturing companies, in which all take part, but associations of 1,000 other kinds: religious, moral, serious, feudal, general, restricted, enormous, or diminutive. The Americans make associations to give entertainments, to found seminaries, to build inns, to construct churches, to diffuse books, to send missionaries to the antipodes. In this manner, they found hospitals, prisons, and schools. It is proposed to inculcate some truth or to foster some feeling by the encouragement of a great example. They form a society. Wherever at the head of some new undertaking you see the government in France or a man of rank in England, in the United States, you will be sure to find an association. I met with several kinds of associations in America, of which I confess I had no previous notion. And I have often admired the extent, the extreme skill with which the inhabitants of the United States succeed in proposing a common object for the exertions of a great many men and inducing them voluntarily to pursue it. So anyway, once you started having these corporations, these nonprofit corporations, there was a need for rules. Like, who are members? People that have the right to vote. What about electing leadership? What about meetings, annual meetings? What about quorum, voting requirements, et cetera? And so corporation laws were founded to achieve that purpose. And so these are some of the points I address in this article that I just finished writing on some of the advantages of church membership. So before you run into a non-member form of organization, there are some things to consider, such as voting rights. You know, non-members don't have any right to vote. There's no need for parliamentary procedure if you don't have members. Avoiding vicarious liability, members are not liable for what other members do in a church. That's not true for non-members in all cases. Risk management often can be superior, not always, in a membership organization, because there's a greater accountability to more people in the church who might be interested in demanding and insisting on rudimentary risk management procedures. You know, a leadership team might say in a non-membership church, we don't want to we don't want to pursue protection of children's workers. We don't think we need to do that, and so they don't do that. Well, that's horrendous. If you have a group of 7 or 8 people making that decision, that's one thing. It's much less likely that's going to happen when you broaden that decision-making into membership. And then you've got church discipline. There's no right to dismiss or discipline non-members. In fact, that's a legal risk. The leading case on church membership in the history of the United States is the Gwynn case right here in Oklahoma in 1990. And that serves to this day as the pattern and the standard among courts throughout this country. And people have a constitutional right, the court concluded, to resign membership in a church. But once they do resign and they cease to be members, the church loses any authority to discipline them, unless they have waived that right through bylaw provision. So you can have in your bylaws, which I think is a very important provision, once somebody is under discipline, they forfeit or waive or lose the right to resign. That was not done in the Gwynn case back in 1990. The church had not done that. So that's a very important provision in bylaws if you don't have that. And then number 5, the qualified privilege. The law confers upon you a qualified privilege from liability for statements made among members on matters pertaining to matters of interest among members. So, for example, you have a long-term bookkeeper that's dismissed for embezzlement, but you don't want to tell anybody. And so you finally decide, well, we better tell the congregation. If you restrict that to a membership meeting, maybe after church on a Sunday morning or evening, we're having a membership meeting, and you restrict your comments to members only, there's a qualified privilege that arises. And you can't be liable for what you share, even if you say she committed embezzlement, so long as only members are present in that room and you don't act maliciously. So that's a very important protection that does not apply in a non-membership context. Inspection of church members, only members, records, only members have a right to inspect records of a nonprofit corporation. And tax-exempt status. The IRS has made some comments in some recent rulings involving tax-exempt status of churches or religious organizations generally, that especially when it's a family-run church or ministry, that's evidence that maybe we need to take a closer look at this. Maybe this organization is not properly exempt from tax. Unless they have a broad-based membership. You know, if it's no members and the church is governed by a family, there's potential problems with the church's tax-exempt status. Some recent pronouncements of the IRS would indicate. So anyway, these are some of the issues. There's four or five more that I address. I've never done this before. I've had a lot of requests to do this. So there you go. Another development is my book, Pastor, Church, and Law, that came out in 1983. Many of you probably still have that. Then it came out with a second edition in 1990, third edition in 2000, fourth edition in 2007 as 4 volumes. I've finished writing the 5th edition. Last weekend I did that. No, not really. You know, I just passed the 40-year mark, and it's actually 80 years I've worked for the General Counsel, because I learned long ago to do 2 things at once. And so I've learned I can talk. I have an operator's headset like this, hands-free. I can talk to people on the phone and at the same time be working on an opinion or a letter to somebody else. I have tested this to try to do 3 things simultaneously, and I admit I can't do it. There's it's impossible for me, so I'm sharing my weaknesses here. So anyway, I'm coming out with the 5th edition. I've finished writing it. Now it goes through all the editing process. But it may be called American Church Law. I think we finally have decided to stick with Pastor, Church, and Law. It's going to be 1 volume, replacing the 4-volume 4th edition. It's going to be easier to use and navigate. And many districts in the Assemblies of God and many other non-AG denominations require candidates for ministry to have some training in legal issues. And what are you going to do? Give them a 4-volume treatise? You know, here's what you need. So I think it's going to be a lot easier to use this text again like it was in previous editions, with it being just 1 volume. As I said last year, I do a review of all church litigation in this country, and that means reading every case involving religious organizations. Nobody else does this to my knowledge. And it turns out there's and this has been constant for many, many years, 12,000 cases a year. So it's not going up. So I can tell you without hesitation that there's not an explosion in church litigation. It's been constant for the last 20 years. Why are churches sued? Well, by the way, that works out to about 1,000 per month I have to read, and that works out to about 33 cases a day, 7 days a week. Some of these cases are hundreds of pages long, some of them 10 pages. Probably, let's say the average is 20. So that'd be 660 pages of legal opinions that I'm reading every day. Fortunately, God has given me the gift of speed reading, but I have very little comprehension. And not really. I have enough to know it, to put together this data. So here's the answer for why were churches sued in 2017? Sex abuse of a child was the number 1, followed by property disputes, personal injuries, zoning, and insurance disputes. Now, up until 2016, there had been 20 years of me doing this research where child abuse was the number 1 risk for churches. And then in 2016, it dropped to number 2, second place. And it went from 11.7% to 8.3%. Man, I thought that's a tremendous trend line. But then, so I was anxious to see the data for last year, and unfortunately, it's back up to first place again, pretty substantially. Just over the past month or two, couple months, I've reassessed my own attitudes, my own views when it comes to the issue of child abuse. We've seen it's the number 1 risk facing churches, but there's been 6 or 7 developments in the last 6 months or so that are striking, that have really changed the rules and have just intensified the need for churches to be sure that we're properly vetting people to whom we entrust our children and adolescent children. And let me share some of those. The rising tide of public outrage. It's visceral. The outrage and revulsion of the public, and that's our jury pool, by the way, with regard to churches where child abuse occurs. Let me give you some examples. The federal youth sports legislation that was enacted by Congress a few months ago because of the horrendous cases of child abuse in the Junior Olympics program by the trainers at Michigan State University, which, by the way, recently reached an out-of-court settlement of $500 million with a B, $500 million. $500 million settlement Michigan State's going to pay for about 400 victims. And when I looked at the testimony of people, what's called testimony for the legislation, legislation doesn't just happen. There's usually an opportunity for the public to comment. And the abhorrence, the loathing that these people, it was emotive by which they described this evil, led to a 318-2 vote, by the way, on that legislation. Can you believe that? The California case earlier this year, the first court in the history of this country, from my analysis, to decide that a charity was responsible for a case of child molestation because it didn't do a criminal records check before they hired him. That involved a youth soccer league. You have the national, the state, and then the local chapters. This is in California. And I'll come back to that case here in a minute, but we had a California court finding that national and regional and local chapters liable because they didn't do a background check. Then you had the specter of this Pennsylvania grand jury report that was issued a few weeks ago. 2 years in the making, 1,400 pages, which I've reviewed. And then I sent a 10-page summary to Doug Clay, and he immediately said, Rich, I want you on the agenda for the next executive press review meeting, which by the way, I'm on the executive press review now as an auditor. Brother Clay feels that there's enough legal issues that come up that it's good to have my expertise readily available, as opposed to being in my office saying, Rich, could you come down to the conference room? And then I know nothing of the background of what I'm being asked to do. One time, years ago, the General Superintendent, Brother Carlson, called me into an EP meeting. I knew nothing of what was going on. And he looked at me and he said, Rich, what's the answer? He just assumed I was in there for the whole meeting. I didn't know what he was talking about. I said, well, I'd be glad to provide the answer if you'd share what the question is. I just said, listen, if in doubt, the answer is no. So that case, you read the 1,400 pages, there's two things that stand out in that case. Number one, transfers of bishops transferring child molesters from one parish to another. They couldn't believe it, this testimony. And then you had the failure to report abuse. These bishops didn't report abuse of hundreds of Catholic priests. This is in Pennsylvania, 6 of their 8 dioceses. So that instructs us as to what we must do. And then number 5, the Brooklyn Diocese settlement. You may have read this a couple weeks ago in the media. The largest per person settlement for a child sex abuse case in American history. $7 million each for 4 victims of one priest in Brooklyn, New York. You got number 6, 20 Catholic dioceses are in bankruptcy today. They've already paid out a total of $4 billion in settlements in child abuse cases. So that's kind of setting the stage for the outrage, the escalating outrage people have toward this evil. And we see that in the AG steps that are being taken. Some of you may be aware that the Northern California District, has proposed a resolution that the General Presbytery has reviewed a couple of times to add to the grounds for discipline of Assemblies of God ministers a minister that does not institute a proper screening program for youth workers, and then it's defined what that means in a separate booklet. So I was opposed to that, and because of my opposition, it largely was tabled. But after this rising crescendo of outrage, I've changed my mind. We cannot be in the position, churches, districts, general council, of letting one of these cases slip through and be on the front page of the paper and have that moral outrage that we're going to experience. We've got to do more. And so I told Jay Herndon, who is the Secretary Treasurer, I said, Jay, I'm on board. I've been so overwhelmed by the negative developments. So that's a general council bylaw. So what the general council does in session, they've got to approve it, bylaw amendments. I don't know what's going to happen, but I'm on board with it. And as I've seen, number 8, as we've seen, the number 1 basis for lawsuits against churches, child sex abuse. And so the question is, you might ask yourself, how would a jury in Oklahoma view our risk management program at our church? or at our district. You talk about these district youth activities, children's camps, youth camps. Those are high-risk situations that we need to be sure we're engaging in proper risk management. So criminal background checks, I mentioned that case in California. The court concluded defendants, these are these soccer organizations, had a duty to require and conduct criminal background checks of defendants, employees, and volunteers who had contact with children in their programs. Bang, there it is. Now, here's my current risk management recommendations. This is the most important thing in your handout. Do you have 10? Are there 10 there? I constantly am amending this. So anyway, I want to run through this with you. This is what I consider to be the gold standard. This is if you follow this checklist, and this is not difficult to do, I think you are in a very, very low probability of litigation, even if a child is molested. You're not automatically liable. You have to be shown to have been negligent. And with this, I don't think that that's reasonably possible. Number one is an interview. If the person is not well known to you, what is your interest in youth ministry? A written application. Number three is probably the most important thing on this list, and that's obtain institutional references from other institutions such as churches, schools, youth sports teams, etc., with which the applicant has worked with minors. And getting a written reference, or telephonic, most are done by telephone today, that we know of no reason why this person would not be suitable for working with minors in your church. That's the gold standard. If you have 2 or 3 of those, that's what you want above everything. Number 4, a 6-month rule. We don't allow anyone to be a volunteer worker with minors who has not been a member of our church for 6 months. You get to know the person better. Number 5, benchmark church policies by comparing them with the policies of other churches and, most importantly, the public schools. You're sending a bunch of kids to a fine arts festival or to a Bible quiz meet, or any number of reasons why kids in your church go on out-of-town overnight trips. Contact the public school district, find out what they do. They have overnight trips for kids. How do you handle that? What kind of risk management protocols have you adopted? And the thing is, if you align your practice with that of the public schools, which is an instrumentality of the state of Oklahoma, how can you be liable? How can you be negligent for that? So whatever the case may be, what's your sleeping arrangement in a hotel? How many kids and adults in a room? If you find out what the public school policy is on that, and you follow that, there's no way you're going to be found negligent. Number 6, periodic review of your policies by legal counsel. 7, adopt a 2-adult policy prohibiting a child from being alone with an unrelated adult. 8, a criminal background check consisting of a nationwide search of sex offender registries and a national criminal file search. Many denominations and insurance companies offer special pricing. Number 9, promptly report prompt reporting of child abuse that's known and suspected. The General Counsel has been sued 4 times over the last 10 years in cases where a minister was dismissed, in part because of child molestation. Fortunately, there are very few of these. And no report was made to the Division of Family Services where we are in Springfield, Greene County. And I was just kind of stunned when we got the first one of these lawsuits. I mean, in what sense do we have to report suspected child abuse? Does the executive presbytery have to report? Is that a reporting entity? You know, it says no person, or any person shall report child abuse. So we have started probably 7 years ago now reporting to our local county Division of Family Services. We've reported all cases where a minister is disciplined by the General Counsel Credentials Committee in part or in whole because of child abuse. Physical, emotional, sexual. And at first they thought we were crazy, but now they're accustomed to it, and they refer it to the county where the alleged incident occurred. We do that maybe 5 times a year now. But we have a history of 7 or 8 years now where anybody that we discipline because of child abuse in any manifestation, that's reported immediately. So that we've cut off that argument being made against us. And then number 10, very important, promptly halt high-risk behaviors, such as minors spending the night with an adult, going on trips together, minors spending time in an adult's home, grooming behaviors. The General Counsel is being sued, has been sued over the last few years for $100 million in one case of child abuse involving 2 Royal Ranger leaders and probably a total of about 12 boys that we know of back in the 1980s, 30 plus years ago. That's an existential threat to the Assemblies of God. What's going to happen if that, and this is in a very blue state, hostile to religion, especially Christianity. And so that's got my concern. I'm concerned about that, but we're doing our best, and we'll see what happens there. But what was involved in that case was these rangers would pick up boys over the weekends or after school, not having anything to do with the ranger program, and be driving them all over the place. Taking them to their home, taking them to the mall, taking them on overnight trips. That kind of behavior is a red flag, and that should not be tolerated by rangers, Sunday school teachers, or anybody. Note, criminal records checks are not sufficient. There was a case involving a Baptist convention in Florida that was attempting to start a new church, which they did. They brought a pastor in. They did a criminal background check on him, but they got no references. And he had no criminal record, so they hired him. Come to find out, he'd molested children in Maryland and Alabama in previous pastoral assignments. And those pastors of those churches said, we would have happily told you about those prior incidents, but nobody asked us. So that convention, Florida Convention Baptist Church, was found liable by a jury for $12.5 million. And what did they do wrong? They said, how can we be liable? We did a background check. You didn't get references. So we need to look at what we do to protect children as a basket of things, and I've given you 10. You need to get those references plus the criminal records checks. That's the lesson of that case. The next bullet, how often do we repeat background checks? I get asked that question all the time, and there's no right or wrong answer to that. The best answer is to contact your local public school district and find out how often they repeat criminal records checks. In Oklahoma, like every other state, every school employee, public school, has to go through a background check, criminal. And if you find out what the state's policy is on that and follow that with regard to repeating background checks, you're home free. And I've discovered in some states, they never require it. And some states, they do. It may be in 5 years, 7 years, 8 years. There's a variety of answers to that question. So just be sure you confirm what the state of Oklahoma mandates, because every school employee, teacher, teacher's aide, cook, chef, accountant, janitor, bus driver, they all have to go through a background check. So I was dealing with a church in Wisconsin recently. They did a background check on a youth worker and found out he'd been convicted of resisting arrest 7 years before. And they asked me if that disqualified him. So we looked up the statute in Wisconsin that defined the crimes that rendered somebody ineligible to teach in a public or be employed by a public school, and come to find out that was not on the list of 37 crimes. So I said, well, he could work at a public school. Why in the world could he not work at a church? So they used him. Now, the next one, criminal liability. Yeah, the next one, high profile. There was a high profile case. You would know the church, it's not AG, if I told you. They were sued for a case of child abuse. The plaintiff's attorney questioned the pastor whether the church's screening, selection, and supervision policies and procedures had been reviewed by an outside expert to see if they met or exceeded the best practices for the industry. That's the kind of question you can expect to be asked. Criminal liability of a bishop in Philadelphia, 7-year prison sentence for not reporting child abuse last year. We've talked about criminal liability, recent AG litigation. One victim potentially poses an existential threat. If it does to the general counsel, it certainly does to the district or to a local church. Reporting supersedes the clergy privilege. I don't care if, this is not true for Oklahoma, but in many states where ministers are excused from a duty to report abuse, if they learn of it in the context of a privileged communication, meaning in the course of spiritual counsel. I've changed my view on that over the last 5 to 10 years, and it doesn't matter if it's privileged. I think that needs to be reported. But we'll come to the Oklahoma statute here in a second. And then the last couple of points here, extended statutes of limitations basically mean that these child abuse cases can go on for decades. The case we're dealing with the Royal Rangers, that's over 30 years old, 35 years approximately, those incidents took place. It doesn't make any difference. And then, so that says that you need to be sure if you retain those insurance policies for the church and never throw those things out, because that's going to be your ticket to have legal counsel appointed and paid for, and any judgment or settlement paid for on your behalf up to the insurance policy limits. Never throw out those insurance policies. So we talked about this. Now here's the Oklahoma statute on child abuse reporting. It's the 4th column. Everyone in Oklahoma is a mandatory reporter, and there's no clergy privilege exception. So there you go. Ministers in this state are mandatory reporters of child abuse, period. Of abuse that you have reasonable cause to suspect or to believe has occurred. You don't have to have absolute certainty. And the clergy privilege, this could be in the context of a confidential confession. Somebody comes into your office and confesses to molesting their stepdaughter, who's a minor. You got to report that, even though it's otherwise a privileged conversation. That's kind of the most restrictive group of states of all of these. Insurance, I'm going to pass over this. The one comment I want to make about insurance is this. Is number 1 here, disputes with, we saw that's number 5 issue in litigation involving churches is insurance disputes. The most important thing I could tell you about your insurance policies is to read the exclusions in your liability policy. Does it exclude sexual misconduct? Most of you, the answer is yes, it does exclude that. And so you need to confirm with your insurance carrier whether we have coverage as a church for the most common claim that we face or risk, and that's child abuse. And if you find out that you don't, I mean, you need to get a special endorsement if possible, or switch coverage. Something else I'll mention at number 5 is the extraterritorial exclusion. We're, the general counsel, involved in litigation involving a car accident in a foreign country where an adult man, a church member that was on this mission trip to a different country in the Middle East, was paralyzed because of an accident he received. And the general counsel has $1 million limit on extraterritorial accidents. Most churches have no coverage. So if you send a group on a short-term missions project to Mexico or to another country, just remember at the boundaries of the United States, your insurance no longer exists. So you need to supplement that. Never even consider taking people across national boundaries without having adequate insurance. Just a couple other issues I want to cover today. One is computer privacy, because this comes up all the time, and then we'll take your questions. What we're talking about here, I'll just set the stage here by giving you an actual case I dealt with just a few weeks ago, where a church contacted me, and the youth pastor had gone into the senior pastor's office. The senior pastor called him and said, "Would you come to my office to discuss something?" While he was sitting in there, the youth pastor just happened to notice the laptop computer on the pastor's desk was turned slightly so that he had he had partial vision of the screen. And he saw what he later would describe as what he considered to be child pornography. And when the pastor left for out of the building appointment later in the afternoon, the youth pastor decided to go in and check the computer out. And sure enough, he confirmed his suspicions. There was child pornography on that computer. So the question is, what do we do about it? I mean, did we violate the law to inspect that computer? Can we use that evidence against him? That issue was addressed by the United States Supreme Court in 2007 in something called the Kwan case. And it provides kind of the roadmap for us to resolve these cases. So this comes up a lot, and I just want you to be aware of the legal principles that apply. So here's what the Supreme Court said. Number one, employees have a legitimate need or expectation of privacy in their workplace. Employees have a legitimate expectation of privacy in their workplace. But that can be negated in two ways. Number one, consent, that can be expressed. For example, you have a written computer policy that employees sign, or it can be implied. If you're a large church, you have an IT person that continually goes around and updates and maintains computers, you just have to assume they're going to inspect your computer. That's not true for most churches, that second one. And then number two, the employer's limited authority to search, the Supreme Court said, if the employer has a legitimate work-related reason for the search and the search was not excessively intrusive in light of that justification. So that's the heart of that Kwan case. The employer has limited authority to search if the employer has a legitimate work-related reason for the search and the search was not excessively intrusive in light of that justification. So there have been two cases involving churches. In the one in Wisconsin in 2002, the court ruled that a church and its senior pastor, secretary, business administrator could be sued by a former youth pastor who was dismissed as a result of pornographic materials that were discovered on his office computer. That again was a case of child pornography. And we had a case involving the general counsel many, many years ago where a pastor had raped a number of 8 to 10-year-old girls and took movies of his behavior. And he put these cassette tapes in his storage locker, one of those rental storage locker facilities. And he didn't pay his rent for a couple of months. And that gave the owner the right to go in and take anything out of there and sell it. And he found these cassette tapes. And he said, well, what's this? And he started playing them. And he later testified he threw up on the floor. He was so sickened by what he saw. And he called the local police. They brought in the FBI. And I was in a meeting where this evidence was on the table. There was an FBI agent in there. And the interesting thing to me was he would not even touch that cassette tape, that VHS tape, whatever it was, because federal law says the mere possession of child pornography results in an automatic 5-year prison sentence, no parole. Second offense, 15 years. So he was afraid he was going to be guilty of a federal felony by holding that cassette tape. It was like toxic. And then the second case in North Carolina, where another former church minister claimed that the church had violated his rights under federal electronic privacy laws by searching his laptop computer for pornography. And then the court in that case concluded it dismissed the lawsuit on the ground that it was barred by the First Amendment guarantee of religious freedom from resolving what it considered to be a dispute involving the qualifications of a minister. That's kind of an odd result, but that's one of the two cases that have addressed this issue. So the bottom line is, you need to have a computer policy at your church. And there's a number of things that need to go into that policy. If you want to contact me, I'd be happy to send you kind of a template of what I'm talking about here. And you can reach me, by the way, at my email address, which is legal@ag.org. For any issues that come up, I'm happy to talk to you. I have probably 95% response rate. I mean, like I've said, you're looking at the legal department. So it's something that I will respond to personally, probably a 90% at least response rate. But I have a sample computer policy you can take, review it with your board, and decide if it fits your needs. Maybe you need to amend it. But here's some of what I consider essential provisions. The policy should only cover employer-owned and provided computers, not an employee's own personal computer. Number two, the policy should clearly describe authorized and unauthorized use. Next, the computer policy should describe possible consequences of inappropriate use, such as discipline up to including dismissal. It clearly should authorize the employer to, and here's the key, the employer can access, monitor, analyze, and inspect its computers. Keep in mind, this is your computer. This is not the employee's computer. And so don't you have some right to inspect? And the Supreme Court in the Kwan case said, hey, you do, but the employee also has a legitimate expectation of privacy. The policy should state that employees have no expectation of privacy in church-provided computers or contents, that the church will cooperate fully with law enforcement. The start screen reminds employees of the terms of the computer policy. The policy should explain the work-related justification for the employer's right to access its computers. For example, monitoring inappropriate or illegal use of the internet, monitoring excessive use of the internet, access to information on employees' computers in their absence, preventing copyright violations by employees, minimizing the risk of computer viruses, updating computer-owned software, detection of communications among employees that may constitute sexual or other forms of harassment. So these are some of the justifications for your policy, and I think it's important to put those in the policy. Explain the policy to new employees, have them sign a statement they agree and are to be bound by this as a condition of their employment, and on it goes. Explain the policy to all new employees. Some of this is just obvious common sense. And then the final one there is the computer policy should affirm that the church retains ownership of both its computers and the data stored on them. Let's move on now to the Masterpiece Cake Shop ruling. That was a highly prominent case earlier this year. The Supreme Court ruled by a vote of 7-2 that a decision of a Colorado Civil Rights Commission imposing penalties and sanctions against a Christian bake shop owner for refusing to provide a wedding cake to a same-sex couple based on his religious beliefs violated the First Amendment guarantee of religious freedom. The important takeaway point in this case was it had nothing to do with the merits of the case. This ruling only dealt with the fact that this Civil Rights Commission in Colorado did not treat religious belief with proper deference and respect. Members of this so-called Civil Rights Commission in Colorado demeaned Christianity, made fun of it, and they said the baker's Christian beliefs they likened to the Holocaust, and what else was it? And to slavery. So, they were demeaning the bake shop owners' religious beliefs, and the court said, you can't do that. You've got to apply your analysis in a very neutral way, treating religion with respect. So the point to understand is this was not a ruling on the merits. This was a ruling that was quite limited, that you cannot, in penalizing Christian bake shop owners for not providing cakes to same-sex couples, you've got to look at you've got to be consistent and treat all organizations with proper respect. So the point is, one commission member, yeah, I mentioned that. So the point is that all you need to do is find inconsistent activity by these civil rights. Every state has these civil rights commissions, and like in Oklahoma. And what you have to do before they can apply these laws to a Christian business is to look for inconsistencies where they treated, for example, in one case, the commission treated kind of a new age group with greater deference, treated them with great respect. and then a Christian group. There was a group of atheists that were treated with great respect, not a Christian group. So you got to be consistent. And as long as you are and are respectful of religion, the state has the right to punish people for violating these laws. So then you come over here, what is the impact of this ruling on pastors, churches, and businesses? The court made this statement that was gratuitous. It didn't have to say this. It didn't have to address this issue. But the court said, when it comes to weddings, it can be assumed that a member of the clergy who objects to gay marriage on moral and religious grounds could not be compelled to perform the ceremony without denial of his or her right to the free exercise of religion. This refusal would be well understood in our constitutional order as an exercise of religion. So there's a strong statement by the United States Supreme Court of the ability of clergy to engage in discriminatory treatment with respect to marriages. You can't be punished for refusing to perform a same-sex marriage. What about churches? No direct impact, not addressed. The application of the non-discrimination provisions and public accommodation laws were not addressed. That's the hot issue. The Oklahoma state and local city ordinances that prohibit discrimination on several grounds, including sexual orientation or marriage based on religion. In my opinion, the question in these cases involving churches is going to come down to whether you are a place of public accommodation. And most of you are not, but you possibly could become one by allowing the public to rent your facilities for profit. So I've talked to many pastors that say, oh yes, we make a lot of revenue renting our sanctuary for marriages, but we don't allow gay couples to get married here. You're on thin ice at that point. You don't have to go out to the general public, but if you do, you need to assume that it's possible, if not likely, that you're going to be held to be subject to these public accommodation laws. So that's just something to keep in mind if you're renting your church facility to the general population. Okay. I put together this risk management matrix just a few weeks ago. I haven't refined it. It's a work in process. But what I've done is I've just listed 20 what I consider to be the biggest risks involving churches, and you enter a score of 0 to 5, and then you tabulate your score, and then you have your risk. So 5 would be you're doing a great job, 0 would be you're doing nothing, and you can just fill in the numbers there. Comply with the 8, it's now 10 steps to reduce the risk of child abuse, etc. I'm still working on this, but I think it's going to end up being a very excellent tool that your church can use to very quickly assess what's our exposure to legal liability in our community. Okay, well that gets me through what I wanted to cover today, so let's see if you have any questions on what I've covered or maybe anything else you'd like me to address. I'd be glad to do that. Yes?
Dr. Hammar, I know churches rent out their facilities, but what about churches that don't rent them out but occasionally are asked to provide the facility, and just because it may be someone that is a friend or family of the church, they do so and they don't really charge anything, they just allow them to use the facility. Does that still open up that same risk?
I don't think so. I think it's got to be the commerciality, that we're going out to the public to solicit patrons to use our facility for a fee. I don't think what I'm saying would apply to that in that context. Yes. Yes, well, my longstanding opinion is that you should have rooms, hotel rooms, with 3 adults and 1 child, and one of the adults should be an attorney. I'm trying to be practical. Brother Frank said, make it practical today. So, but here's what I think. Number one, you remember what I said before, the best thing you can do is contact the public school district. They do this. What is your arrangement? And if you follow what they've done, how can you be negligent? You're doing what the state of Oklahoma dictates to its schools. That would be a statewide policy. So that's number one. Number two, just my opinion, having dealt with many, many, many of these cases, is I think the best thing is to have 4 children and no adults. I mean, if we're talking about adolescents, 15 to 18, certainly not 7, 8, 9-year-olds. You need to incorporate adult supervision. But for like high school, maybe even middle school, having 4 kids in a room without adults. My church had on a trip several years ago, 2 adults and 2 teenagers in each room, and even there, we were told by the father of one of the boys, a month later, he came to me personally, just weeping. And he said that on that trip, his son had been sexually molested. They had 1 adult and 1 child in each of 2 beds. And he was sexually molested by that guy. And so that guy was involved in youth and children's ministry in our church for years. And I always wondered about him. Why is he never's in adult groups or high school groups. He always is hanging around the young children. And so when we decided as a board he had to be removed from that position of leadership in children's ministry. And his mother, I remember, was very distraught that we took that action. I said, we've done it for temporarily. I mean, he's free to reapply in a year. We'll take another look at it. Well, I saw that mom about a year later, and I said, your son is, if he wants to reapply, we'll be glad to reconsider. And she said, well, I don't think he will because he's having problems with his sexual identity. So we knew what the story was. He eventually left the church. He was deep in the gay lifestyle. And pedophile lifestyle. A pedophile is not synonymous with homosexual. Pedophile is a specific type of orientation to prepubescent minors. It's hard to believe, but these are people that have a sexual preference for 8, 9, 5, 4-year-old children. So for example, in the grand jury report in Pennsylvania a few weeks ago, it's interesting. They said the vast majority of these cases, 1,000 cases of abuse that they recounted, were teenagers. What does that mean? These priests, these 300 priests, were not pedophiles. They were homosexuals. But the media cannot call it homosexuality because that would hurt a privileged status in our society, being gay. And but the fact is, it is a homosexual activity. So when you see a case of child abuse, and it was a 13, 14, 15, 16-year-old, that is not pedophilia. Pedophilia is the 8, 9-year-old. Now the thing about pedophilia is it's incurable, it's promiscuous, it's predatory, and it's got the highest recidivism rate of any crime. In other words, the repeat rate. So it's a toxic risk in a church, pedophilia. That's going to be your Royal Rangers, the younger ages from 5 to 12, we'll say. That is your prime target right there, because pedophiles, the FBI profile on pedophiles, the 3rd edition of it, it's about 200 pages, lists 7 different kinds of pedophilia. And it just says it's almost impossible to tell in advance somebody's a pedophile. It's much more likely you can tell somebody's a homosexual. But pedophiles often go under the radar. You can't identify them in any way. And the profile says there's a number of factors that are suggestive somebody's a pedophile. And the most common, the highest, what should I say, the most likely evidence that somebody's a pedophile, although it's not conclusive, is somebody that frequently is photographing children. So you think about that for a minute. At my church, we had a guy, when our son was 12, that would go around to all of his basketball games, wearing basketball uniforms, shorts, jersey, and he would sit under the basket and take rolls of pictures of these children. And I mean, I had just been reading through this profile. I knew immediately this guy was a predatory pedophile. So think about your church. You have that guy with a camera. Now it's easy with a cell phone. Takes pictures, but in the old days it was harder. They had to bring a camera with them. And you thought to yourself, why is that guy taking pictures of these kids? We just dismiss it, and we think it's okay. That, according to the FBI, is the highest evidence that somebody, not conclusive, but it's the best evidence somebody's a pedophile. And again, all of a sudden, you've got someone that's predatory, promiscuous, incurable, and the highest recidivism rate. It's a toxic risk to the church. They've got to be excluded. And how do you do? And you can't have a 100% safety net. I mean, but we have to do our best. That's why I've intensified my own recommendations. That list of 10 recommendations I gave with you today, that I just finished a few days ago, last week. And I highly urge you to review that with your church leadership, your children and youth leaders, and act accordingly. Did that respond to your question? Who's next? Yes, sir.
Let me go back just for a second on renting your building. You said soliciting, renting that. I mean, is there a difference between, like, we have a charge, an outsider uses it, so is that the same?
The idea is, commercial activity, that you're going out into the public soliciting people to use your church. Well, how does an outsider know that your church is available? They come to you? I think you got a better case there. It's the affirmative steps of going out and advertising the church or making people aware. You're taking affirmative steps to increase commercial revenue. That's the worst case to be in. If you're just passively responding to people that come by, like a gay couple comes and says, we want to get married here, is that okay? And so what do you say? We don't rent to gay couples. You're in potential trouble in terms of publicity. But what you can do is have a church policy that we only allow our church to be used for weddings by members, or at least one party is a member of our church. And so then when that gay couple comes and says, we want to get married here, say, well, I'm sorry, we only allow members to be. And that's totally neutral and safe. You're not going to be on the front page of the paper as bigots. Anybody else?
On the risk management, page 3 of this.
Yes.
It says to obtain institutional references from other institutions.
Yes.
What if it's the first time for the individual to work with?
It's a good question. Everybody has a first time. That's a small number of people. You can't get references under those circumstances from an institution where he's worked with minors. So what do? I think you have to do personal references, but I would restrict it to the extent possible to members of your congregation, rather than somebody in Wyoming that you've never heard of before. Because you remember the FBI profile says this, photographing children, big risk. These are people that their only adult friends tend to be other pedophiles. So sure, they're going to give a good reference. But you don't know who these people are. That's a risk for you, unless it's somebody in your church. It's a good question. Yes, ma'am.
Our daughter just retired, fresh out of Bible college, to be a children's pastor.
Yes.
And to our knowledge, she was not asked for the background check, or there was not one done for her. This is the state of Texas. Did she do anything about that, or advise us?
Well, as a new employee, you got to be careful, of course, but I would suggest you give her that list of 10 recommendations by probably the leading authority in the country today. Nobody's done more work on this field than me. When my younger daughter, Holly, was like 5, when I got home from work, many, many times, she would say, Daddy, did you save any lives today? And I never knew exactly how to answer that question, but I would say, I don't know if I saved any lives, but I think I helped a lot of people today. And nowhere is that more true than in this field. When I came out with that Reducing the Risk of Child Abuse kit in 1992, some of you have seen, half the churches in America got that resource. 200,000 of that product were distributed. So, I mean, how many kids were spared this nightmare because of that? It's kind of what keeps me going. It's hard work. I work 7 days a week. It's almost, I shouldn't be taking a Sabbath off occasionally. That's right. Don Gifford, the superintendent in Indiana, every time he sees me, Richard, have you gone on vacation? And I say, Brother Don, my work is my vacation. He says, yeah, I know, that's the problem. So I confess. So I would give them that list of 10 recommendations. If that church is not doing most of those, they are a target, and there's going to be consequences.
And that's nationwide, there's no exemption. That was part of my question.
No exemption from what?
No exemption from the responsibility.
Oh, no. This would be generic. It would be consistent in all 50 states. Yeah. A church that follows that, and it's not going to take forever. You have staff that can do a lot of this work. You're going to be in such a good position in the event. We're not talking about eliminating risk. We're talking about managing risk. The only way to eliminate it is to put a sign above the front door, no minors allowed here. And then, you know what? You're risk-free. There's not going to be any child abuse going on. But most of us don't want to go that far. I'll share this story with you. I've had so many wonderful things happen teaching 5th grade Sunday school. And one of them happened last year. I had a kid that was a foster child. Horrible abuse. His name was Matt. He went by Matthew. And I remember he came to my class. He knew nothing about the Bible. Who was Moses? I don't know. Did you ever hear of Noah? No. Jesus? I think he'd heard of Jesus. He had no idea about the Christian faith. And the second Sunday he was there, we just happened to be talking about the tabernacle and the costume that the high priest would wear. And I said, when he went in on Yom Kippur to the Holy of Holies with blood to sprinkle on the mercy seat, if the bells on the bottom of his robe, if the people outside heard those ringing, they knew that God had accepted the sacrifice. And there was great joy in the camp. And I said, that sense of joy has gone down through Jewish history, and then the Christian church picked it up immediately with the concept of bells, handbells, steeple bells. What do they signify? Jubilation, because God has accepted the sacrifice, not of a sheep, but of the Lamb of God that takes away the sin of the world. What an amazing parallel. And so anyway, I said, when you hear bells ringing in church steeples, just pause and reflect that God has accepted the sacrifice to redeem us from our sins. We ought to be jubilant. Well, later that day, the class ended. We're walking downstairs for me to take the kids to children's church. And we just happened to walk past this door that faced a Catholic church 3 blocks down the street, St. Joseph's Catholic Church. And immediately, as we walked past the door, the bells started tolling. And I thought, isn't that neat? Well, I didn't know Matthew was walking right behind me. And he said, Dr. Hammar? I said, yes. The Lord has accepted the sacrifice. That's affected me to this day. I was about to quit teaching after 35 years. I changed my mind that day. Any other questions? Yes. If somebody like that, you can penetrate the heart of a 12-year-old that has zero understanding of Christianity, that taught me a lesson that day. nobody is outside the scope of what we can do down here.
My understanding is that the general counsel now requires a background check of all potential people. If you are either hired staff or if you are a pastor search committee, should you ask for another background check of that individual?
For staff members?
Staff, or if your pastor search committee is putting together new pastors?
Well, keep in mind, in the AG, it's not all pastors. It's pastors at every level of credential. Certified, licensed, ordained. At every level, you have to go through a background check. So, and that's been true now for like 8 or 9 years, I think. So a lot of pastors in the AG have been. But people that were ordained when this happened and don't have any higher place to go, they're not going to have a criminal background check. And I think that's a good policy to have that done. And that would include the National Sex Offender Registry plus the National Criminal File. You can do both for under $10.
So it'd be good to do that even though they may have been through that?
Well, you see, now if they have been credentialed at any level since about 2000, 2004, whenever that, we'll find out when that happened, they may have already gone through a criminal background check.
Should we, if they have been through that, should we consider asking them to do it again because whatever?
I don't think that's necessary. Yeah. Yes, ma'am.
If you have a staff member that you hire, and it's a lady that is certified, but her husband is not part of that ministry, and his work ethics are not what a pastor would want them to be, can that pastor fire that staff member because of her husband?
Well, I suppose you could, but is that staff member a credential holder? Yeah, yeah. So can they terminate the credential staff member because of the husband? You can, and there's no liability for doing that, but it's just a matter of propriety. Anybody else? I can't see here. Brother Frank, I'll turn it back over to you.